America, Tom Hand here at the Americana Corner. Today we're discussing the landmark Supreme Court ruling of Marbury versus Madison. On March 2nd, 1801, 2 days before leaving office, President John Adams submitted to Congress a list of 58 names, all Federalists, to fill positions created by the recently passed Judiciary Act. But Secretary of State John Marshall was unable to deliver all the commissions before Thomas Jefferson was sworn in as president. Jefferson directed his Secretary of State, James Madison, to not deliver the remaining commissions, one of which was for a Justice of the Peace position for William Marbury. Marbury then sued, requesting the Supreme Court issue a writ of mandamus, which is a court order compelling a government official to perform a legally appointed task. In this case, the writ would force Madison to deliver Marbury's commission. On February 24, 1803, John Marshall, who is now the Chief Justice of the Supreme Court, issued his landmark ruling. To everyone's surprise, the Chief Justice denied Marbury's request and dismissed the case, stating that the law authorizing the writ of mandamus was unconstitutional, and thus, for the first time in the young nation's history, declared congressional legislation invalid. This was significant because it went against Jefferson's Republican principles that the will of the people was paramount, and that legislation passed by elected representatives could not be overruled by unelected judges. Prior to this ruling, the federal judiciary was clearly the weakest of the three branches of government, but no more. With this one decision, Marshall created the domain of the judiciary in our constitutional government and made it a branch co-equal to the legislative and executive branches, as the framers of the Constitution had intended. In his decision, Marshall stated, "It is emphatically the province and duty of the judicial department to say what the law is, and henceforth that would be the case." In this one sentence, John Marshall succinctly encapsulated the concept of judicial review, that the courts have the sole authority and responsibility to review laws passed by a popularly elected legislature and to declare invalid any that conflict with the Constitution. This concept of the review of legislation by an independent judiciary, free from political control, is uniquely American. While other countries grant judges some level of review authority, none allow judges at virtually every level to overrule legislation passed by elected officials in Congress or executive orders by the President. For better or for worse, the Marbury decision established a precedent that in America, judges decide what the law is. While Marshall's Marbury decision aligned perfectly with Federalist principles, it conflicted perfectly with the Republican ideas of President Thomas Jefferson. And he did not plan to take Marshall's decision lying down. Next week, we'll discuss the impeachment of Supreme Court Justice Samuel Chase. Until next time, may your love of country lead you.